So a big welcome to Yana, Simutina and Vitalii Dudin, two labour law experts, lawyers, joining us from overseas. So Yana's from Ukraine, but based in the UK at the moment. Vitalii is speaking to us from Kyiv. Tonight we're talking about labour rights and the war in Ukraine. How does the labour relations system work in Ukraine? What are some recent reforms happening? And what are the concerns there? Tonight's forum is free, but if you would like to make a donation to Vitalii's NGO to help their important work in supporting workers' interests and unions active in Ukraine, I really encourage you to do so. And I've put their details up in the chat. Just before I introduce the speakers, I wanted to give a quick plug to our recent book, the Australian Institute of Employment Rights new book, A New Work Relations Architecture, which picks up on a bunch of these themes, but in an Australian context, gives an overview of what we think a fair industrial relations system would look like for Australia and how we can lift Australia's standards closer to international and fundamental standards, how we can create a fairer system. Okay, now I'll introduce the speakers. And you can order that book from our website, by the way. And I'm just going to let in a few more people. From the waiting room. There we go. Okay, so you've got it in the flyer there, but our first speaker is, so basically we've got the professor and the activist. So our first speaker is the professor. Yana Simutina is a senior research fellow at Koretsky Institute of State and Law of the National Academy of Sciences of Ukraine and a professor at the National Technical University of Ukraine, as well as a visiting professor at the University of Bristol Law School, where she's working at the moment. Her research interests encompass labour law and social rights in the digital era, non-standard forms of work, and the scope of labour law in the gig economy. In 2019, she was actually a member of the working group tasked with drafting the new labour code of Ukraine. And for the last 4 years, she's been a member of the scientific and advisory board under the Supreme Court. So thanks for joining us, Yana. I'll give a quick introduction to Vitalii also, and then throw over to you, Yana. So Vitalii Dudin is a leading trade union solicitor in Ukraine and the head of the board of Social Movement, a Ukrainian NGO promoting labour rights. He has a PhD in legal sciences, specialising in labour law and social security law from the Donetsk Law Institute of the Ministry of Internal Affairs of Ukraine. And for the last 15 years, he's provided legal aid on a pro bono basis to workers in the Ukrainian healthcare, transport and mining industries. And he's been involved in training and organising campaigns for Ukrainian trade unions. Vitalii is also a legal researcher at the Centre for Social and Labour Research. His research interests include monitoring neoliberal reforms in the labour relations field, the precaritization of work, atypical employment, and social reforms related to European integration. So, okay, now it's very great pleasure to have you both here. We're honoured and thank you so much for donating your time. I'll now hand over to Yana, who's going to speak for about 40 minutes, and we'll leave questions to the end. Thanks, Yana.
Hello to everyone again, and thank you very much for this introducing me. And first of all, I'm very pleased to be invited to this webinar and grateful for the opportunity to speak about the challenges that Ukraine and national labor law faced since the large-scale Russian aggression against Ukraine on the February 24, 2022. Today, I'm going to talk about how labor regulation works in war-affected Ukraine. And just let me share my presentation. Yeah. And actually about the ongoing labor reform in Ukraine. And firstly, I'd like to start with some general information about the labor regulation model in Ukraine and describe briefly the situation in Ukrainian labor legislation over the last couple of years before the full-scale war with Russia. So let's start with the labor regulation model in Ukraine and the role and place of trade unions and social dialogue in it. The labor market in Ukraine has a complex legal framework that regulates and sets certain standards and restrictions. And the International Labour Organization listed 574 legislative acts in the field of labor, social security, and related human rights. Ukraine ratified 71 ILO conventions, of which 61 are in force. 6 conventions have been denounced, and 3 instruments abrogated. However, the Ukraine is, so to say, a front runner in the region where, when it comes to the number of ILO conventions ratified, there is still work to be done with putting international labor standards into practice. And a prominent example is the Ukrainian labor inspection system. The 2 ILO conventions stipulating the core rights, powers, and functions of labor inspection have only been partially applied. So traditionally, labor relations in Ukraine are regulated at 3 levels. The first one is legislation level. Second is collective agreements level. And third is individual level. It's mostly employment contracts between employer and employee. There is a general rule in the labor code that terms of agreements, of employment agreements and collective agreements that worsen employees' rights compared to the labor legislation of Ukraine are invalid. And this is the general protection rule of employees' rights. And the Labor Code is the principal legislative act governing employment relations in Ukraine, adopting in 1971 when the country was still part of the Soviet Union. The code has been amended at least 140 times, but it's still not in sync with the modern changes in the economic landscape and social relations. And also, the negative side of Ukraine's current labor legislation is a chaotic character of legal improvements that implies quite a few legal collisions. And perhaps one of the most striking issues in the labor sphere over past 20 years in Ukraine is the long-awaited adoption of a new labor code. Talking about the role and place of unions and social dialogue, I'd like to emphasize that social dialogue in Ukraine entails all types of negotiation, consultation, or exchange of information between representatives of social partners, which usually represent government institutions, or trade unions, and employers' organizations, on common interest issues relating to economic and social policy. It can take place at the national, regional, territorial, or enterprise level. And the main idea that it is regulated by the relevant law on social dialogue, but the effectiveness of social dialogue in Ukraine is quite limited. So today's social dialogue, as I mentioned, regulated by the law of Ukraine on collective contracts and agreements and the law on social dialogue. On the 23rd of February 2023, this year, the parliament adopted the bill on collective bargaining agreements and contracts revised, and it will come into force 6 months after termination of martial law. And the bill is aimed at enhancing the role of collective bargaining, labor relations, and strengthening the protection of the rights of employees and employers. Also, its implications are yet to be seen when it comes into force. And also, I'd like to say that it contains some controversial provisions, but we'll see will be it applied effective or not after the termination of martial law. The trade unions law from 1999 regulates trade union activity and establishes rights and guarantees and procedures for the registration and activity of unions, irrespective of sector, occupation, profession. And the law covers almost all professions concerning forming trade unions, except the restrictions that apply to military officers during services, prosecutors, and judges. As we moving forward, union density collective agreement coverage is also might be interesting to know about Ukraine. And to date, the largest trade union in Ukraine is the Federation of Trade Unions of Ukraine, which was established after the country became independent in 1990. It counts 4.36 million members and about 71% of total trade union membership. According to the report in 2020, the Federation of Trade Unions consisted of 45 all Ukrainian trade unions and 25 trade unions just local trade unions. Its membership rate shows a declining trend, and from around 26 million workers during the 1990s down to 7.8 million in 2012, and then to 4.3 million in 2021. Talking about the collective bargaining coverage, it's based on the enterprise level, and according to different estimates, this coverage declined from 76% in 2014 to 73% in 2019. Overall, it is mostly the public sector that contributes to this high coverage rate. The private sector, as well as new forms of work, and by the way, Ukraine has one of the largest numbers of digital platform workers in Europe, are hardly covered. And trade unions and employers' organizations face difficulties in recruiting new members from these sectors. Another key challenge is that collective agreements often do not cover controversial topics like wages, working conditions, or equal treatment for women and men. And finally, collective bargaining agreements are seldom enforced. As we move ahead, let's have a look at the most striking issues of labor law reform in Ukraine preceding the Marshall period. And as I already mentioned, in Ukraine, the idea of adopting a new labor code has been around since national independence, and about 5 attempts to do so were reported. However, none of them was successful. The government that came into force and power in September 2019 announced an ambitious 5-year plan to boost GDP growth and create over 1 million new jobs, and reforms of industrial and labor relations played an important role in realizing their plans. In this context, initiatives introduced by the government aimed to liberalize labor legislation, pursuing more flexibility for employers to hire and dismiss workers, and to strengthen individual labor relations. The work on revising labor legislation started in late 2019 after the government submitted a draft labor law, which moved away from the traditional codification of labor legislation, putting forward the free regulation of the employment relationship on the basis of individual agreements between an employee and an employer. Such an approach is unusual for Ukraine if we bear in mind the peculiarities of the national system of law, in which the state played a significant part for a long period of time, and many relations were regulated mostly by an imperative method. The draft was criticized by national and international trade unions and seen as a limitation of workers' rights. And concurrently, the Committee on Issues of European Integration of the Verkhovna Rada of Ukraine, it's the name of Ukrainian Parliament, stated that the document weakens labor protection, narrows the scope of labor rights and social guarantees of employees in comparison with current national legislation, and contradicting Ukraine's obligations contained in the association agreement and failing to comply with EU law. And after all, the unsuccessful attempts to adopt a new labor code caused by a disagreement between the government, trade unions, and employers led lawmakers to make targeted amendments to the current version of the labor code. And in 2020, a number of draft laws were therefore tabled in as disparate legislative initiatives, retaining and aggravating the fractured nature of current Ukrainian labor law. Some of them are under evaluation by the national parliament, while others have already entered into force. Most important amendments in Ukrainian labor law before the full-scale war with Russia. First of all, we should recall that the COVID pandemic introduced some labor-related regulations, and actually the COVID crisis raised the stakes for the reform high, as it called for the urgent filling of legal loopholes. And as a result, Ukrainian parliament introduced some new laws. It regulated, for example, flexible forms of work organization and remote work, the possibility of granting unpaid leave for the period of quarantine, as well as the introduction of a business interruption mode. It's worth mentioning that these new rules became, in many cases, the only possible option for employers to organize the work process and for employees to continue working during the most difficult weeks of war. And the existence of relevant legal provisions on the possibility of introducing remote or home-based work in case of emergency by an employer's order without the need to conclude a remote work agreement in writing actually enabled many employers and employees to preserve their employment relation at the beginning of the war. Also, this law has solved most of the urgent problems pertaining to remote work. It should be acknowledged that in some cases, legal regulation still remains unclear when implemented in practice and needs some improvements. In 2021, the law on amendments to certain legislative acts of Ukraine on accounting for employee activity in electronic form was also approved. It sets norms to replace hard copy bookkeeping with electronic accounting of employee activity in the Register of Insured Persons of the State Register of Compulsory State Social Insurance. And the third significant step of lawmaker in 2021 was actually the introduction of the concept of gig contracts and gig workers into the legislative field through the adoption of the laws on stimulating the development of the digital economy in Ukraine. The concept of a gig contract was introduced by the government to tackle a common practice in IT industry of engaging the workforce under civil law contracts and also with a view to improve working conditions and providing social guarantees. But in fact, mostly for tax optimization. And this is a hybrid type of agreement, I mean, big contract, between an employer and the worker, which contains elements of an employment contract with certain social guarantees and a civil law contract with elements of freelancing. Not to mention about this controversial hybrid form of agreement, which is actually more like, which is know-how for all the world because it contains like mostly of labor and employment guarantees, but the government called it civil law contract. So I won't tell much about this hybrid agreement because we don't have really time to do this, but it's a very interesting and controversial step of the Ukrainian lawmaker. And amidst all the optimism about the ongoing digitalization of the economy and the various breakthroughs and achievements of IT companies, a crucial element of the digital economy, the lowest level workers who provide services on platforms like Uber or Glovo, has been still overlooked in Ukraine. And there is no appropriate legislative model for regulating the work and guarantees for such digital workers. And next, I'd like to discuss the impact of war in Ukraine on fundamental labor rights. And the first issue in this context is, of course, the restrictions of labor rights under martial law. And as you probably know, martial law was introduced in Ukraine on the first day of the full-scale Russian aggression on 24th of February 2022. And drawing from the historical experience, the imposition of martial law is always a challenge for fundamental labor rights, such as an elimination of all forms of compulsory labor, the freedom of association, and the effective recognition of the right to collective bargaining, the freedom of workers and trade unions to engage in collective actions, and of course, one of the unconditional consequences of the introduction of martial law is the prohibition of strikes and other collective actions, which directly follows from the law of Ukraine on the legal regime of martial law. It worth to mention that the limitations of labor rights established by the said law are based on the norms of the Constitution of Ukraine. And of course, it was a first step of our government and parliament. But interesting that during the relatively short period of time, legislative activity in the regulation of labor relations has increased significantly. And the first step of the Ukrainian legislature was the adoption of the law on the organization of labor relations in martial law in March 15, 2022. This law says that in relation to certain labor issues during martial law, the provisions of this law will prevail over the provisions of the labor code. And the provisions actually of this law, they increased significantly the rights of both private businesses and state employers while reducing the rights of employees. Just to give you some examples, as a result of hostilities, a company can no longer function. It can dismiss employees with 10 days notice instead of 2 months, and the payment of one's 1 month's salary. It is also permissible to dismiss employees who are on sick leave or vacation, but not if they are on parental leave. Employers can increase the working week from 40 to 60 hours, shorten holidays, and cancel additional vacation days. They also have greater possibility in hiring employees and can require employees to do other work not covered by their contract if it is necessary for some defense purposes. And another new provision, quite controversial, which concerns the suspension of an employment contract, can be applied according to this law in connection with the military aggression against Ukraine. This temporarily relieves all parties from mutual obligations, but does not terminate the employment relationship. And the payment of wages and other guarantees and compensations is assigned to the state committing military aggression, meaning Russia, and not the employer. And I should say that there is no mechanism, real mechanism of how this rule will work and how we can get this compensation from Russia. So it's also a provision which caused some concerns and is quite uncertain. Also, this law gives employers the right to cancel collective labor agreements during the martial period and significantly limits the rights of trade unions, reducing their role to one of civilian oversight. Of particular interest in the context of the limitation of labor rights in wartime are issues of compulsory labor and socially useful works. And one of the measures of martial law is to introduce labor conscription for able-bodied persons not involved in defense and vital functions of the state, and not reserved for enterprises, institutions, and organizations for the period of martial law. Labor conscription is applied in order to perform work of defensive nature and eliminate the consequences of emergencies that arose during martial law. It also enables to involve citizens in socially useful work performed to meet the needs of the armed forces of Ukraine, law enforcement agencies, and civil defense forces, ensuring the functioning of the national economy and life, personal safety or health of the population, and does not require, as a rule, special training of persons. And for those who are involved in socially useful work, the previous position, work position is retained for the time of such work, and they also receive monetary compensation, which cannot be lower than the minimum wage and retain their regular the national minimum wage. And therefore, the first trend of reforming labor legislation in the conditions of martial law is for the restriction of fundamental labor rights. This was obviously a first step. Nonetheless, under martial law, a new stage of the ongoing reform of labor legislation of Ukraine has begun. And wartime actually became an excuse for Ukrainian government to accelerate this reform, aimed apparently at the regulation and reduction of employee protection. And as we can see, liberalization of labor legislation is a priority for the government, which, taking advantage of the weakening constitutional restrictions on trade unions, continues to try to implement it under martial law by passing the legally defined procedures of social dialogue. Let's go further. And the second trend of reforming labor legislation and the conditions of martial law is deregulation or simplification of labor relations. And in the summer 2022, new terms appeared in the legislation of Ukraine as optimization, deregulation, simplification of labor relations, introduced by the relevant laws. And I'd like to discuss the second law, which is number 2434, and on amendments to certain legislative acts of Ukraine on simplifying simplifying the regulation of labor relations in the field of small and medium enterprises and reducing the administrative burden on entrepreneurial activity. If we look at the lexical meaning of the word simplification, it obviously means facilitation and removal of obstacles. But even a superficial analysis of the law 2434 gives reason to say that this law in its essence is a veiled attack on the rights of employees and has nothing to do with simplifying labor regulation in the strict sense of this word. This law introduced the so-called simplified regime to labor relations, which arises between an employee and an employer who is the subject of a small or medium-sized enterprise with an average number of employees for the reporting period of no more than 250 people. And the second criteria as for this simplified regime, it can be used between an employer and an employee whose monthly salary is more than 8 times the minimum wage established by law. The logic of the legislator who has proposed to expand the limits of contractual regulation for the mentioned two categories of employees is not fully understood. And what is the reason for this criteria and specifically defined amount of wage is also a rhetorical question. But in the conditions of the simplified regime, the employment contract is the main mean of regulating employment relations between employees and employers, not legislation, not labor code, and so on. And in case of application, this simplified regime of regulation of labor relations by mutual agreement of the parties, the employment contract may define rights and duties and responsibilities of the parties, conditions for early termination of the contract, etc. And it's obviously de facto means removing up to 70% of the country's workforce from the protection guaranteed by national labor law. And moreover, this law remains discriminatory in nature and does not comply with Article 24 of the Constitution of Ukraine, International Labor Organization Convention number 111 concerning discrimination in respect of employment and occupation, as it provides actually division of employees into several categories with respect to the level of protection of their rights under labor law. The next trend of labor law reform in Ukraine I'd like to talk about is the further legalization of non-standard forms of employment. And on July 18, 2022, the law on amendments to certain legislative acts of Ukraine regarding the regulation of certain non-standard forms of employment was adopted. In fact, this law, despite its telling name, introduces only one type of non-standard employment, so-called work on demand or on-call work, and introduces one type of employment contracts with non-fixed working hours. This legislative change, in the view of Ukrainian lawmakers, may be useful in overcoming undeclared employment or employment under civil law contracts. And that follows from this law, an employment contract with non-fixed working hours is a special type of employment contract, the terms of which do not specify a time for performing work. Such an obligation of the employee arises only in the event that the employer provides the work without guaranteeing that such work will be provided permanently. Therefore, the specific time of the work is not set, and the work is provided on availability. And an employment contract with non-fixed working hours may also establish additional grounds for its termination, etc. However, when entering into an employment contract with non-fixed working hours, the worker would receive at least some labor guarantees and social protection. For example, the law states that employees under such agreements are not limited in general employment rights, the right to vacation, etc. And it also emphasized that the working time of an employee should not exceed 40 hours and 6 days per week. At the same time, the minimum duration of an employee's working time during a calendar month is 32 hours. So the salary is paid for actually work time or performed work, depending on the relevant remuneration system. However, if an employee didn't perform work at all during the calendar month or performed it for less than 32 hours, he or she should still be paid the salary for at least 32 hours of working time. And the law also provides that the number of non-fixed hours employees of one employer cannot exceed 10% of the total number of his employees. So there is like some equilibrium between labor and employment protection and the regulation, as we can see. And this employment contracts with non-fixed working hours, they are not like 0-hour employment contract, like for example in the UK. But of course, it's also a question of how these guarantees and social protection, which is obviously is in this law, will apply on practice. And okay, the next trend, the last actually trend I will discuss today, is the implicit decodification of Ukrainian labor legislation. In September 2022, the new draft law on labor was presented for public discussion. The proposed law should replace the current labor code. In fact, despite its telling title, this law is intended to regulate only individual employment relations and doesn't contain any provisions on collective bargaining, collective agreements, collective labor disputes, and which are supposed to be regulated by separate laws. And in this context, it is important to stress that Ukraine belongs to a civil legal system, with codified law being one of the main features. And the history of codified labor legislation in Ukraine dates back 100 years, since the first labor code began to operate in 1922. Today, there are over 20 different codes in Ukraine, for example, civil code, criminal code, etc., which have norms for particular branches of law. And by careless elimination of complex codified legislative act in the sphere of labor, we are at risk of gaining negative consequences of substantial and massive quantity misbalance of legislation. And moreover, the analysis of the draft law shows its absolutely liberal ideology of equality of the parties to an employment contract, which by the nature of the relationship itself is not true and leads to negative consequences for employees, and to the maximum elimination of the state regulation, particularly in matters of ensuring effective employment, decent working conditions, adequate wages, etc. And to conclude, I'd like to emphasize some general remarks. The first one is that labor reform in war-affected Ukraine points towards further deregulation and liberalization of labor relations, as well as introduction of non-standard forms of employment into the legal field, and the decodification of labor legislation. Obviously, changes in labor legislation in Ukraine are inevitable as reality. New global trends in the labor market need reaction and response. And also, everyone would agree that in wartime, legislative intervention of the state in the sphere of labor relations is also required. However, unlike the restrictions introduced exclusively for the period of martial law, most of the unjustified wartime changes of the rules on the labor market might remain in peacetime and have inevitable negative consequences for Ukrainian workers. And before I leave the floor to Vitalii, I'd like to show my last slide and ask a question. Is the wartime the right time for labor relations deregulation? If we look at the ILO Centenary Declaration on the Future of Work, it recognizes that decent work is key to sustainable development, particularly in areas affected by conflicts, disaster, and other humanitarian emergencies. So labor rights in wartime, in my view, might be temporarily and reasonably limited for the sake of national security and preservation of the state. However, even under martial law, labor rights restrictions cannot be arbitrary and unfair. They must be established exclusively by the Constitution and laws, and pursue a legitimate goal and be transparent and justified. And of course, restoring labor rights as well as ensuring that they be an integral, that they would be an effective, should be an integral part of the post-war future. And thank you for your attention. I give floor to Vitalii.
Thank you, Yana. So over to you, Vitalii. Anyone who's chomping at the bit there with a question, please just hold that thought to the end. We'll have time for questions then. Thanks, Vitalii. Over to you.
Okay, thank you very much for organizing this event. Thank you, Yana, for presenting in such deep details the system of labor law in Ukraine. I follow in your scientific articles, as you know, with a big interest, and it's a big pleasure to read your reflections about the dynamics of Ukrainian system of labor law. Now we are living in the time of dramatical changes, which are caused by the war and by the neoliberal reforms that take place in Ukraine. And I will try to represent my critical overview of the reforms which take place, and about the harm which was caused by these reforms in the aspects like growing of social inequality. And I will try to predict what will be the next dynamics of development of employment legislation, and what can social and trade union activists suggest as an alternative, as some alternative priorities for changing the labor legislation. So I will show you my presentation. Let's start. The topic is work at war, how neoliberal reforms during wartime affect workers' life in Ukraine. As James introduced me, I am Vitalii Dudin. I am head of NGO Social Movement from Kiev. It is a democratic socialist organization which stands for workers' interests, and I am a PhD in labor law. And also I involved in providing legal aid for Ukrainian employees. So the first slide, peculiarities of labor law of Ukraine. Thanks to Yana, you know how is the complicated the system of labor law that exists in Ukraine. It is a plenty of legislative acts which were adopted in different time, in different conditions. But I like this system of legislative acts because although it complicated, but it gives the feeling of stability to plenty of people. Before the war, about 10 million people worked as employees on the basis of employment contract. So despite the narrowing of influence of labor law, despite the development of such phenomena like undeclared work, millions of people still had a legal job. They worked in labor relations. And this system of labor law is very detailed and very strict. So it is a good protection against abuse from employer side by contractual freedom. It was before the war, but of course a lot of things changed. And I want to stress that the Ukrainian labor law system, and especially Ukrainian labor code, has something in common with such countries like Bulgaria and Poland, who still have a labor code adopted in socialist time, but those labor codes were modernized, were renewed according to market conditions. And if we talk about the most essential point of Ukrainian labor code, I will say that it ensures strict and detailed provisions on remuneration, working time, and rest time, as well as protection against dismissal. And the content of labor and the collective agreements can be changed only for the purposes of improving the position of the employee. It is a general rule. So what was changed in the time of war, in the time of full-scale Russian aggression against Ukraine in 2022. There were adopted several legislative acts. The most sufficient, the most essential was law on organization of labor rights, labor relations in the time of martial law, or law 2136. It was adopted on 15th of March of 2022, and it suspended several labor rights guarantees, and I think this law had very harmful implications, and also a series of other laws had been implemented, like law 2434 about the special regulation in small and medium enterprise. Also, there is a law 2421 about so-called labor agreements with unfixed working time. So if we talk about the general tendencies, I will stress the following. I think that the adoption of neoliberal changes during time of war caused the violation of the balance between the parties of labor relations. Why? Because employers acquired an opportunity to impose some actions in a unilateral way. It means that the employer can impose some acts against interests of workers in one-sided way. For example, Law 2136 on organization of labor relations in the time of war gives an opportunity to employer to suspend labor contract in one-side manner. Also, some provisions of collective agreements can be also suspended by employer. And the law 2434, which imposes so-called special or simplified legal regime for the small and medium enterprises which employ less than 250 persons. It gives an opportunity to dismiss worker without the reason, but with payment of small compensation. And of course, such unilateral actions, they harm the workers, because such actions they cannot be effectively blocked, and of course it's a big problem. Also, I see the problem of abuse of freedom of labor contract. Employers can initiate some changes in the context of employment relations, and the workers have no effective remedies about the possible worsening of their situation. For example, employer can change working conditions, for example, to cut wages, and if worker is not supports this idea, if workers not if worker disagrees, so he will be dismissed with received 1 monthly average salary. And before the war, worker should be warned 2 months in advance. But now there is no such safeguard. The employer can impose new working conditions even 1 or 2 days in advance, and that's all. And also employer can conclude so-called labor agreements with unfixed working time, and it does not guarantees receiving of a job on a permanent basis. And before adoption of law 2421, which will be still in force after the war, it was prohibited. If a worker is employed, he should receive work and salary, which should be not less than minimum wage as a rule. And also I see another example of abuse of freedom of labor contract. Laws number 2421 about so-called labor agreements on unfixed working time, and the law 2434 about simplified regulational regime for small and medium enterprise opened the opportunity to prescribe additional grounds for dismissal in labor contract on the basis of agreement of parties. And of course, if a worker is interested in getting a job, he will agree, yes, on it. And of course, it's a big threat to the stability of employment relations. And also, I want to add that flexibility was not compensated by institutional safeguards. We talk not about the healing of and balancing labor law. No, we are talking about the growth of flexibility which harms the security of workers. It's not the flex security, because it was not accompanied with some legal and social safeguards. No, employer can dismiss employee in more simple manner than before, but our legislators did not raise the level of support for unemployed person, for example. And also, after loosening of regulation, our legislator did not strengthen the labor inspections in order to control the actual level of compliance of employers with labor legislation. So I think that this experience could not be recognized as successful, because employers acquired additional rights, but they did not obtain some new restrictions and limitations. Also, I can name a few negative effects on the labor market. I think that Ukrainian labor market under such dynamic neoliberal reforms becoming less stable and predictable. I see the problem that those legislative changes are undermining social partners. As National Service of Mediation and Conciliation said, the level of activity of Ukrainian trade unions is going down. They admit that trade unions initiated much less labor collective disputes in the previous year, and they see the limitation of trade unions' rights as possible precondition for that. So I think that we will face, and we already face it, but it will be worse and worse, the tendency of falling down the membership of trade union. And I think that it will not solve the problem of social tensions. Yes, we have less collective disputes, but we have a growth of individual labor disputes. So I see that the field of employment relations is very conflict. Yes. Also, I see the problem of labor market segmentation. Before the wartime, our labor market was very homogeneous. Yes, it was like a single market, because most of people who worked on the basis of labor agreement, they worked on standard full-time and permanent contracts. But now we have some contractual differentiation, because employers receive the incentives to use some atypical forms of employment, and Ukrainian trade unions have no experience how to effectively oppose the abuses arising from the using of atypical employment relations. So I think that incentives for using fixed term employment contracts, 0 hours contracts, or on-call work contracts, specifics of regulations applied for small and medium enterprise, they can weaken the solidarity between the workers and cause the rise of precarious employment. And also, I see the problem of growing unemployment. About 3 million people are being unemployed, but only 150,000 citizens are registered as unemployed in state employment service. I think that the rest of people, they do not want to register because now our government implied additional conditions for registration and limited the level of unemployment benefits. And also, I think that a lot of people, they are in the mode of suspension of labor agreements. They are not performing work, but they do not receive money from their employers, and they are not in situation which gives them opportunity to receive unemployment benefits, because they are still recognized as employed person. So we have a problem of so-called hidden unemployment, and it distorts labor market. Talking about labor disputes during the wartime, I want to express my personal thoughts based on my experience. I see that the biggest problem, it is non-payment of wages, especially in healthcare sectors. Also, a lot of workers are suffering from failure to obtain work because they are still employed, but employers do not provide them with any tasks. Also, there is a problem of illegal dismissals. Sometimes people do not receive the proper justification, or they even do not receive any document why they are recognized as dismissed person. So, of course, it is a problem. It is a problem of uncertain status of people, and it needs more time in the time of war to establish the fact of labor law violation, and it becomes more difficult to receive information about your employer, because company register is not working as easy as before. So people sometimes could not know even the actual address of their employer. Also, I see some changes in the behavior of employers. As I said before, they do not inform workers in a transparent manner about some changes in labor relations, or even about suspension or termination of contract. And also, employers tend to interpret new opportunities in a broad manner. For example, when our legislator introduced the opportunity to suspend labor agreements due to the military aggression of Russian Federation against Ukraine, a lot of employers all over Ukraine understood it as a possibility to suspend the relations with every worker and to save the money. Yes, but this interpretation was not correct. It was not in compliance with the spirit of this extraordinary legislative provisions. Also, I see some law enforcement problems because courts are working with some limitations. Of course, in some regions, there is no access to the justice because of hostilities. That's true. But even in the regions where courts still operate, there are problems with blackouts, with air raids, and the underfunding of courts, and all of those factors affect the duration of trials. And even if we talk about some cases where illegal nature of dismissal is obvious, it takes about half a year to prove that the employee is right. Yes. So I think that our courts can work better, but of course there are some objective reasons. I want to say that some cases show us that courts can effectively solve labor disputes even without the presence of parties in the court room. Yes, we have so-called simplified procedure for the resolution of labor disputes, but this option does not work in every situation. Yes, in some cases, courts still summons the parties in intercourt or uses telecommunication technology. And also, I want to add some optimist figure. Yes, wartime created a new category of labor disputes. It is contesting the orders of employers on suspension of labor contracts. And I want to admit that according to the register of court decisions, about half of such cases, they were solved in the interest of working. So you have a 50% chance to challenge the order on suspension of labor relations. I think that now law 2136, at least this law, could be revised or even cancelled. I think that this extraordinary law was adopted in some special conditions, and it is no longer justified to enforce such law, because it brings a lot of limitations on labor guarantees, but his positive effect is non-obvious for me. So I think that law on regulation, law on organization of labor relations in the time of martial law could be cancelled. Why? Because now a security situation in Ukraine has stabilized, so restrictions are no longer look as proportional to the threat. So when this law was adopted in the March of 2022, hostilities were on the majority of territory of Ukraine, but now hostilities are localized mainly on the Donbas region and in Kherson region. Also, I think that it is highly necessary to encourage legal employment through increased protection of workers. A lot of people, they do not seek for a legal job because the size of guarantees which they will receive is not it's not enough. Yes, it's not sufficient. So I think that the cancellation of this law will bring additional incentives to people to find a legal job. Also, I think that this symbolical act will contribute to return of refugees from abroad and will help to consolidate our society. In other way, I see some controversial issues because it looks like this beneficial legal regime makes employers interested in saving martial law. Of course, I don't think that all of employers they are thinking that way, but it looks paradoxical. Our workers continue to suffer, yes, and employers has no legal interest in abolition of this extraordinary regulation, which harms, I think, all society in long-term perspective. Of course, I want to improve labor conditions for Ukrainian workers, but I have a feeling that the trend towards liberalization in employment relations will keep in the future. So I want to stress that I see some reasons, some reasons which convince me that we will face the problem of liberalization in employment relations in future, in close future. I think it is because economic crisis, which is ongoing in Ukraine due to hostilities, and employers are interested in putting some burden, economical risks on Ukrainian workers. Also, I see the lack of democracy. Trade unions cannot effectively oppose drastic changes in employment relations. Trade unions are under attack. Our MPs like Halina Tretyakova, the head of so-called Social Committee of Verkhovna Rada, openly attack unions, arguing that they are corrupted, they are outdated, and even International Labour Organization is outdated. I think it's very dangerous rhetorics which undermines social dialogue. But that's true. Also, we have no left or socialist or social democratic parties in Ukrainian parliament, and it also distorts the quality of debate at the highest level. And of course, trade unions have no possibility to organize strikes, and it is difficult to organize massive protests on the street. And everything mentioned jeopardizes the strength of our union in order to promote their alternative vision. Yes. Also, I want to add that our government and parliament is united on the basis of so-called deregulation trend, and they are not stand for deregulation only in labor sphere, but deregulation in labor sphere. It is particular example of policy of deregulation in general. And I think that our legislators are inspired by the experience of such countries of European Union as Estonia and Hungary. I think that those countries have dramatically changed their system of labor relations by imposing some civil law principles, civil law methodology in the field of relations between worker and the employer. And I think it is very risky way. And also, as I know, the quantity of trade union membership is falling, is dropping in these countries, so they could not be the proper example of social dialogue and the creation of best practices. Yes, so I think that Ukraine should orient on the better experience. So what should I propose? I think that we should look at labor law from another perspective, rather how to adjust it to the needs of some employers who suffer in the economical crisis. I think that our state should bear more responsibility. Our state should become more active player in the field of employment relations, and it should invest more financial resource into creation of workplaces. It should incentivize the development of public sectors in fields like healthcare, logistics, transport, machinery. Yes.
Vitalii, if you wouldn't mind wrapping up in the next minute, just so I had some time for questions.
Okay. Yes, so the main principles should be mitigation of inequality, democratization of workplaces, and protecting the well-being of employees. Yes, here you can see some my concrete proposals. Yes, and finally, I want to tell some lessons from Ukraine. The main lesson is that deregulation, including simplification of dismissal, do not lead to job growth. This neoliberal myth did not work in Ukraine. Also, ignoring social dialogue during war turns into rapid deterioration of working conditions, with the risk of conservation of this situation in long term. And the final point is that the worst forecast did not happen. Yes, we still have a lot of labor rights, and it is still possible to fight for better future, even in conditions of both war and neoliberal reforms. Thanks for attention. Sorry for violating some time limits. It was a big pleasure for me to be in your company.
Thank you so much, Vitalii. If you wouldn't mind just stopping your sharing. Yeah, thank you. Yeah, thank you so much. And also to Yana, that just raises so many questions for me, about the role of decent work in sustaining a war effort, in the economic recovery, the moral obligation that we have to people engaged in the war effort and to provide them with decent jobs to return to. These global trends that you've spoken to of deregulation, how they're playing out locally in Ukraine. But we're going to go 5 minutes over time just to have a bit extra time for questions, and I'll just throw the floor open now. So please jump in with one or write it in the chat.
Well, I'll start off. Thank you, Yana and Vitalii. That was very interesting, and I must say a little bit disturbing. We have echoes of this here. Of course, we didn't have a crisis like that, but we had COVID, and it was really like a, you know, that Naomi Klein shock doctrine, never let a crisis go to waste. I wanted to sort of interrogate the politics of it. I mean, did the current government come into power on a platform of neoliberal labour law reform, and were the employers pushing for it, or is this a surprise to everyone? Thank you.
Yana, do you have some suggestions?
Thank you for your question, but I really think that this government, its actual plan was to liberalize and to deregulate labor market since it came to power, and maybe it was not so open during the election campaign, and but since they came to power, it started very quickly and dramatically with a massive of draft of laws in different sphere, and of course with a remarkable number of different initiatives, not very fair and justified in the labor sphere. Maybe Vitalii can add something.
Yes, I want you to understand the specific nature of Ukrainian political system. Every party is tend to be more neoliberal than the others. We have something like ideological monopoly at the moment. Yes, because some leftist parties, they were discredited because some of them were pro-Russian, to be open, yes, to be honest. But some of them, they were not effective players, but they were also thrown out from the political system. Yes, and some old political parties of left orientation, they had lost the grassroots connection with the working class. That's why they are not represented in the political system. So the issue of limitation of labor rights become something like mainstream ideas of several Ukrainian parties, including the ruling party, servant of the people. And we observed this problem since 2019, when Ukraine elected Volodymyr Zelensky. And we were disturbed as a representative of left-wing NGO social movement that our government will not adhere to the position, to the voice of working people. And we had the hope that the underrepresentation of workers' interest in parliament could be balanced by some mechanisms of social dialogue, of tripartite cooperation. But in fact, this system of tripartite cooperation is paralyzed. It does not work for a long time because some bureaucratic obstacles, because bad legislation and so on. So now we are in a very bad situation, which gives us opportunity to understand what went wrong. And of course, we need international support. And of course, we are very interested in this event because it gives an opportunity to show what is the situation at the moment and ask for your expertise. I strongly believe that our cooperation with labor law experts from Australia and other parts of the world will not finish after this event. So I believe in strong cooperation.
Thank you. A double barrel question from Keith Harvey, just quickly. Have there ever been any social democratic parties in parliament in Ukraine recently? And how much of the present economy of Ukraine could be said to be working normally today? Any of it or some of it?
If I may, to answer for the second question, as United Nations report estimates, now it's about 35% of Ukrainian economy shrank. So 65 actually percent we can say is working normally today only.
Thank you. Vitalii, did you want to take the other part of the
Yes,
question?
I want to add that previously, before the war, our economy was focused mainly on the exporting of raw materials like iron ore and agriculture product abroad. And now all those possibilities to export such goods freely, they are blocked due to the Russian aggression and blocking of seaports. So Ukraine faces the need to reshape its economy, and we should adopt new economical strategy oriented towards internal market. We should change economy in order to satisfy the needs of economy in wartime. We need more machinery to protect our civilians. We need more arms for our soldiers. We need the restoration of our railway, and of course it is a question of post-war reconstruction. So I think that Ukraine has a big potential, yes, of changing its economy, because we have a lot of educated and motivated working force, but we have no active industrial policy adopted by our government. So I think that social dialogue and international support will help Ukraine to establish more resilient, stable, and prosperous economy.
Thank you. We're going to have to wrap it up there. I just wanted to add that I've read, both of you have written about the possible movement towards EU accession for Ukraine, and that provides some hope for retaining the social dialogue model. So there's some hope there. I just want to thank you very much for both coming. That was an absolutely fascinating presentation. We'll get that up online and send it out for those who couldn't make it. And thanks again for donating your time. And I just wanted to read out one thank you from Professor Joellen Riley from our board, who says, just before she had to leave, Fascinating presentations, disturbing how many similarities we face, the demonization of unions, the push for more use of gig work here in Australia. But of course, we do have the hope here of some federal reforms. Thanks to both speakers for very moving presentations, and all the best with the struggle. All right, thank you, everyone.
Thank you.
Thank you very much.
Thank you very much.
Thank you.